Welcome to Accessing Services for People with Developmental Disabilities. This presentation is made possible through Parent Partners in Health Education, funded by the New York State Developmental Disabilities Planning Council. The slides were created by Susan Lesko, Director of Family Support Services, and Parent Partners in Health Education Coordinator. My name's Elizabeth Wright, and I'm a disabilities attorney. These slides were updated by me yesterday, and I will be guiding you through the presentation. The goals of this presentation are, first, to gain an understanding of the laws that protect people with developmental disabilities who are seeking access to health care and related services. Second, to define the services and service systems that are available to patients with developmental disabilities in our region. And third, to explain how to access specific services that can assist patients with developmental disabilities and their healthcare providers. Before we begin the presentation, it's important to get an historical context in relation to the rights of people with developmental disabilities. Unfortunately, it's not a very pretty history. As early as 1907 through as recently as 1979, people with developmental disabilities were subjected to legally enforced sterilization and incarceration. The Mental Deficiency Act of 1913 specifically prohibited persons with mental retardation to marry and/or bear children. By 1944, more than 30 states had sterilization laws, and in the 1950s, the preferred treatment for a child with a developmental disability was institutionalization of that child. As late as 1970, people with developmental disabilities and physical disabilities did not even have the right to go to school with their non-disabled peers, and millions of children were not in the educational system at all. In the early 1970s, Congress began investigating the lack of educational opportunity for people with disabilities and enacted the Education of the Handicapped Act, or EHA, in 1975. But it's important to know that despite that progress, as recently as 1979, there were laws that mandated forced sterilization of people with developmental disabilities and mental illness. To put it succinctly, somehow in the United States, we were able to figure out how to put a man on the moon before we recognized the civil rights of people with developmental disabilities. The civil rights movement of the 1960s resulted in fantastic gains for the disability community. Some of the laws are mentioned below. The first act for you to be aware of is the Civil Rights Act of 1964, and also the Architectural Barriers Act of 1968. Both prohibited the discrimination of persons with disabilities in reference to their civil rights and their ability to enter buildings and public places. Similarly, the Rehabilitation Act of 1973 made it illegal to discriminate against an otherwise qualified person with a disability in programs or places that receive public funds. It also reauthorized and expanded the National Vocational Rehabilitation Program to include all persons with disabilities and to mandate research and training to improve the vocational prospects for people with disabilities. As mentioned previously, the EHA of 1975, or Education of the Handicapped Act, created an educational entitlement for children with disabilities, specifically the right to a free, appropriate public education in the least restrictive environment appropriate for the child. It also incorporated 7 major legal principles and established the CSC process itself. More about that later. During the 1980s, numerous laws were enacted to provide people with disabilities access to voting booths, telecommunications for people with hearing aids, access to airplanes, fair housing, transportation, and education. Further, the Americans with Disabilities Act of 1990 expanded the definition of disability itself to include any mental or psychological disorder such as mental retardation, organic brain syndrome, emotional or mental illness, and even specific learning disabilities. Finally, the Developmental Disabilities Bill of Rights of 2000 assured that people with developmental disabilities and their families participate in the design of and have access to needed community services, individualized supports, and assistance that promotes self-determination, independence, and inclusion in community life through culturally competent programs authorized by law. So let's talk about the most important laws related to accessing services. First, let's talk about the federal law, the EHA of 1975. That law has been reauthorized by Congress since 1975 as the Individuals with Disabilities Education Act. Note the person-first language, which has been a huge change in disability circles in the last 30 years. Person-first language is of primary importance to people with developmental disabilities. It emphasizes that they are people first and not defined by their disability status. This particular law has been reauthorized several times since 1975, including 1990, 1997, and 2004. The federal law also has companion state laws which implement it. Here in the United States, we have a system that allows states to control education. But federal law always trumps state law. That's based on the Supremacy Clause of the Constitution. So, to put it succinctly, you can have state laws that provide more protection than a federal law, but you can never have a state law that provides less protection. So basically, the Individuals with Disabilities Education Act provides the basic floor of opportunity for children with disabilities, ages 3 to 21, throughout the United States. And our state regulations, the Part 200 regulations of the Commissioner of Education here in New York State, can provide more protection to our children if we so choose, but they can never provide less than IDEA. More about those laws will be provided next. The other law that is very important to accessing services is the Developmental Disabilities Bill of Rights Act of 2000, also previously mentioned. This law lays the groundwork for who is entitled to services and when, and provides the federal definition of disability under the Developmental Disabilities Bill of Rights. First, let's talk about IDEA. IDEA applies to children aged 3 to 21. They are eligible for these services if they fall under one of 13 disability categories and require special education and related services. Once qualified and receiving a free appropriate public education through an IEP, they are eligible to receive services from age 3 to 21 or until graduation, whichever happens first. IDEA incorporates 7 major legal principles that are now defined through case law precedent. These principles include the principle of child find, the principle of zero reject, the principle of non-discriminatory appropriate evaluations, the principle of free appropriate public education, or FAPE, the principle of least restrictive environment, or LRE, the principle of individualized education program, or IEP, and the principle of procedural due process. The interesting piece about IDEA is that it mandates the establishment of a Committee on Special Education process that incorporates the principles that I've named above in a 4-step CSE, or Committee on Special Education process. And these important principles that I mentioned are defined through case law that has gone up through the courts, and in some cases all the way up to the Supreme Court. All of these principles underlie this CSE process. So I will quickly try to marry the two for you, but I will tell you that this lecture in and of itself could take an hour, and I would be happy to share with you my CSE success lecture, which talks about parental rights in this process and how to ensure that children have a successful CSE process. But for now, let's suffice it to say that we have this 4-step CSE process. The first step is identification. And that means we have to identify those children who reside, who are residents in the school district, who we suspect of having a disability. And that suspicion, or reasonable suspicion of having a disability, triggers something called a child find obligation on the part of the district. Remember the principle of child find I mentioned previously. Districts have an overt obligation to locate and identify and evaluate those children residing in their school district, wherever they're located, even if it's in a private or parochial school, and identify them and evaluate them and see if they may be a child with a disability, if they have reason to suspect that. Referrals for CSE can happen in a number of ways, which is another whole lecture, but I will suffice it to say that identification is a key part of the Individuals with Disabilities Education Act. And if a school district shirks this responsibility or fails to appropriately identify children, they are in violation of IDEA, they are in violation of the Part 200 regulations, and subject to a possible procedural due process violation claim by a parent for their failure to identify the child. Once a child has been referred to the Committee on Special Education, has been identified and referred, the next step is to get consent from the parent to see if the child can be evaluated. If the parent refuses consent, that's okay. It's not that great for the child, but the parent has that right. If they refuse consent for evaluation, the district has met its child find obligation. If the parent agrees and consents to evaluation in writing, the district has a further obligation to evaluate this child in a non-discriminatory, appropriate way. We can't have biased testing. We can't have testing that is not in the native language of the child. We can't have testing that would be racially or culturally discriminatory. So that's a key element to IDEA, this idea of non-discriminatory appropriate evaluations. When we get those results back, assuming we got parental consent, we also have to bear in mind the principle of zero reject, which, based in the case law, tells us that if a child has a disability, there is no child that is too severely disabled to be entitled to a free, appropriate public education. Simply because a child has myriad educational needs, we cannot say we won't educate that child. So the idea of zero reject has been defined in case law throughout the years, and that principle of zero reject can be found within the case law explaining what Congress meant when it said that all children, not just some, are entitled to a free, appropriate public education if they qualify as a student with a disability. So there we go with identification and evaluation. Once that happens, there are timelines involved, but the school district has to hold an initial CSE meeting. And at that meeting, there are certain people who are required to be there. But the purpose of the meeting is essentially to determine eligibility. Do they fall under one of 13 disability categories? And if so, by nature of falling under one of those categories, do they also require special education and related services? Having one without the other will not qualify you. Let me give you a concrete example. There are many, as I said, 13 disability categories under the Individuals with Disabilities Education Act. For example, if you were a student who qualified as other health impaired, maybe you have a medical need, maybe you're a type 1 diabetic, and you need a private place to test, and you need to take your insulin, and you need snacks and water and all sorts of things like that, that may qualify you as health impaired, but it doesn't necessarily mean that on a cognitive level you require special education and related services. You may need some accommodations in order to meet those needs, but you don't necessarily require special education. If you don't require special education and fall into one of those 13 disability categories, at that initial CSE meeting, you will not be determined to be a child with a disability under IDEA. However, you may qualify as a Section 504 kid. Section 504 of the Rehabilitation Act of 1973, which I mentioned earlier to you, is a non-discrimination statute, but it also allows that students with a mental or physical disability who are inhibited in the major life activity of learning could qualify for accommodations in order to participate in their general education setting. Student with this type of disability, having diabetes, a type 1 diabetes, might qualify as a 504 student, but not an IDEA student. Just something to keep in mind. Okay, so once we get through identification with consent, the evaluation, and then the initial CSE meeting, if we determine that this is a student with a disability who falls under one of the 13 disability categories of IDEA and requires special education services and related services, then we are to step 4 of the CSE process, which is provision of special education and related services. We actually have to do what we say we're going to do. And what we say we're going to do is memorialized through that principle of individualized education programs. We write down in that document, which is, and the contents of that document is dictated both in IDEA and in the Part 200s, and we actually have a template IEP that the state of New York puts out through the New York State Education Department that we have to follow, and all the components have to be in that document, and we have to actually provide what we say we're going to provide in 4 key areas: social, physical, academic, and management needs for the child. So we're looking at the whole child. We're creating a formalized document that you can refer to as a contract between the school district and the family, saying how we are going to provide a free, appropriate public education to this child, what's appropriate for this child, and where it's going to be provided is the least restrictive environment appropriate to that child. And we're going to be defining those terms for this specific child within that IEP. As I said, a contract between the school district and the child. At all times throughout this 4-step CSE process, when these principles are being implemented as dictated by IDEA and the Part 200 regulations, the procedural due process rights of the family are in play. And at any point in this process, they can claim a violation of those due process rights and pursue remedies against the school district if they feel those rights have been violated. So just to recap, the IDEA mandates each state to provide educational and related services to qualified students with disabilities. And each state must implement regulations that support the federal law. New York addresses that federal mandate with the Part 200 regulations of the Commissioner of Education. So let's talk for a minute about the importance of the Developmental Disabilities Bill of Rights Act of 2000. This is where, in addition to the school-age services that a child can receive through the Individuals with Disabilities Education Act, there are also other support services that are available to a qualified child or adult with developmental disabilities through the Developmental Disabilities Bill of Rights Act of 2000. In order to qualify under this law, though, you must meet the federal definition of developmental disabilities. And that's going to become critically important as we talk a bit about what is available in terms of services for someone who has a developmental disability in the state of New York through our Office of People with Developmental Disabilities. This is a companion to, while they're school age, the Individuals with Disabilities Education Act. You can receive services both through IDEA and through the Developmental Disabilities Bill of Rights Act at the same time, and also continuing on into your adult life. You're entitled to these services because you meet the criteria or the definition under this federal law. So let's talk about if we're going to qualify. We already talked about what it takes to qualify under IDEA, falling into one of those 13 disability categories that are outlined in the law and requiring special education and related services. Separate from that, if you want to qualify for services that are offered through the Office of Persons with Developmental Disabilities and or the Office of Mental Health, if you have a mental health issue, you really have to meet this definition. So let's talk about that. The term developmental disability under the Developmental Disabilities Act means a severe chronic disability of an individual 5 years of age or older that, first, is attributable to mental or physical impairment or a combination of mental and physical impairments. So you don't just have to have one, you can have a combination, you can be dual diagnosed. That's important to know. Second, is manifested before the individual attains age 22. This can be a little dicey for our dual diagnosed folks who maybe, we know, have a developmental disability, but maybe their mental illness or impairment did not onset until a little bit later. But suffice it to say on that most mental illnesses are diagnosed in the late teens, early 20 onset, so or before that. So it's just something to keep in the back of your mind for dual diagnosed folks. The magic age is 22 for eligibility for these services. The third item is that it's likely to continue indefinitely. We're not talking about someone who's going to be magically cured. We're talking about someone who, throughout their lifetime, is going to be dealing with consequences from having this diagnosis. The fourth thing that's really important and can limit people from being qualified is that it's not just having the disability, it's that the disability itself results in a substantial functional limitation in 3 or more of the following areas of major life activity. And those include self-care, receptive and expressive language, learning, mobility, self-direction, capacity for independent living, and economic self-sufficiency. For some people with developmental disabilities, meeting this criteria is not that difficult to do due to their low functional levels. Where this becomes tricky and eligibility becomes tricky is with our more high-functioning people with developmental disorders. For example, someone who's on the autism spectrum who has Asperger's syndrome. They may be incredibly high-functioning when it comes to learning, no problem with mobility, and have decent receptive and expressive language, maybe even some good self-care. Capacity for independent living, self-direction, not so great. Real difficulty with social maturity and ability to function in a work environment. Sometimes meeting these criteria can be difficult for some of the developmental disabilities. And then the fifth criteria reflects the individual's need for a combination and sequence of special interdisciplinary or generic services, supports, or other assistance that's of lifelong or extended duration. So this is the type of person who's going to need job coaching. The type of person who's going on an ongoing basis and throughout their life is going to need maybe nursing support in the home. Maybe is going to need someone to manage their services for them because they're not able to do that. So it's a combination and sequence of special, interdisciplinary, or generic services, supports, or other assistance that's of lifelong, or at least extended duration. So we've talked about the history, we've talked about the specific laws, idea for children ages 3 to 21, and also our Bill of Rights, our Developmental Disabilities Bill of Rights law that talks about the right to access to services. Now we have to talk about where those laws are situated in the system that provides the services. The system is a compilation of government and local entities, and that includes county early intervention programs. So for our little babies, children age 0 to 3 fall under early intervention programs because we want to provide services as early as possible to capitalize on developmental windows for these children. The school districts, who start providing services at age 5 years old. And nestled in there, when we talk about early intervention, there's also the Committee on Preschool Education that's run also through the county, and we'll talk about that. And that's that little age of 3 to 5 that nestles in between the early intervention, which is 0 to 2, and then 3 to 5 is your CPSE, Committee on Preschool Education, and then 5 to 21 is your school district involvement, because that's your kindergarten through age 21 or graduation, whichever happens first. Alongside with that, or sort of parallel with that, is the Office of People with Developmental Disabilities. That used to be the Office of Mental Retardation and Developmental Disabilities. If you're confused by the acronym, it's a change within the last 5 years to the OPWDD, keeping in mind that that's our movement away from identifying someone with a disability by disability first and keeping that person first language. And then the other agency we need to be thinking about when we're talking about where those laws are implemented, where we see them come into play, is the Office of Mental Health, or OMH. So first we're going to talk about, within this system, early intervention services. Physicians and healthcare professionals are expected to screen for developmental disabilities at each well-child visit. So this is something that you're going to have in the back of your mind as you're doing your screenings and your well visits. With parental consent, a physician who suspects a developmental delay in a child under 3 years old must notify the local early intervention office within 2 working days. So there needs to be a procedure or a protocol within the office where the physician is working, where the PA is working, that allows the charting to happen. You've written down what you've observed, you've talked to the family, you receive parental consent, and within 2 days, 2 working days, you make that referral to local early intervention. Now, if the parent does not consent, the physician must document that the parent declined to have their child referred to early intervention and then follow up again within 2 months. Well, why? If the parent says, no, I don't want that, why would they follow up? Well, the research shows that the developmental window within which the EI interventions can have the most impact is in these early years. And if we miss that developmental window, some argue, though not all, that that developmental window is shut, particularly with children on the autism spectrum. So it's imperative that if there's a suspicion that the child has a developmental delay or a developmental disability, that referral happen to early intervention. Now, the parent may have their own suspicion on their own that their child has a developmental delay. After all, they're with the child 24/7, not just at well visits. They may have a clear clue based on their development. Maybe their other children developed typically, and they're noticing that this child is developing atypically. They may also contact early intervention officials in their county of residence without a physician's referral. So that's something to keep in mind as well. Excuse me. It's important to know that in New York State, early intervention is provided by each county's Department of Health. Any child from birth to age 3 with a developmental delay, disability, or condition that affects development may qualify for EI services such as speech therapy, applied behavioral analysis, or ABA. That's specific behavioral therapy that is done by a certified, board-certified behavioral analyst, BCBA. Also occupational therapy, physical therapy, early intervention case management. These are just some examples of what can be provided in the home. Also, there would be an individualized family service plan, or an IFSP. Remember, we talked about an IEP, or an individualized education plan for school-age children. This is what happens for our babies, for our 0 to 2ers in early intervention services. It's reviewed every 6 months because developmental milestones are accomplished so quickly at that early age. And it's coordinated by an early intervention case manager. Information about EI in Erie County can be found at www.erie.gov/health/index.php ? Q equals node/50. If you just get to, that will get you to the specific site with the phone number, but if you just go to www.erie.gov/health, you will get where you need to go if you navigate that site. But keep in mind that the phone number for the Erie County Department of Health, if you suspect that a child may have the need for EI services with parental consent and you're going to make that referral, it's 716-858-6374. Okay, so if you have gone through early intervention services and are continuing on to school age services, if you're 3 to 5 years old, you fall under the Committee on Preschool Education, or CPSE, and if you're age 5 to 21, as I've mentioned, you fall under the Committee on Special Education. What's important to know is that the EI services that we mentioned, birth to age 2, and these CPSE services, age 3 to 5, fall under the county of residence and are paid for by the county of residence. If you are looking to be identified as a child with a disability under IDEA through your school district, age 5 to 21, or graduation, whichever comes first, Those services are paid for with some federal pass-through money and taxpayer money from the district of residence. So it's not a county fund, it's a district of residence fund. And sometimes the variability on what will be provided depends on both the wealth of the county and the wealth of the school district. That is not what is prescribed by law. That is what tends to happen in reality. And sometimes there's a disconnect between what a child is entitled to and what they're actually provided. Just bear in mind, though, that sometimes whether or not a school district is sort of called out on what it is or is not providing is dependent on how well informed the parent is. Parents have a right to know their rights as a parent of a child with a disability, but sometimes school districts fall a little short in providing that information. And I will tell you that the New York State Procedural Safeguards Notice, which goes out to parents and is 42 pages long, is a bit dense and incomprehensible. It's written in legalese. It's a little hard to understand. And in another lecture I do where I talk about students with disabilities, which I'd be happy to provide to you all, I do provide what I call procedural parents' rights in a nutshell, which is a one-page synthesis of the 42-page procedural safeguard notice that parents get in relation to their children with disability under IDEA. But the thing for you to take away today, because we're talking about access to services and the system, is that if a child falls under one of 13 disability categories and requires special education and related services, they will qualify to receive services that result in a free, appropriate public education in the least restrictive environment appropriate for that child. An IEP will be developed by the CPSE or the CSE and it creates a contract between the school and that family that ensures that educational benefit will flow to the child. If no benefit or minimal benefit is achieved, the parent has, I think there's a typo there, due process rights that they can exercise in order to remedy the problem. Okay, so we're still talking about services. There are, in addition to our IDEA services that flow through the school district to the child, we also have services through the Office of People with Developmental Disabilities. OPWDD is run by the state of New York, but it has regional offices. And through the regions, they offer specific services to qualified children with developmental disabilities. Remember, we talked about the definition of what it is to be a child with a developmental disability under that Developmental Disability Bill of Rights. And for certain types of children, there are services that are available through OPWDD. The first type that I want to talk about that's available for children is Care at Home Medicaid waivers for developmentally disabled children, that's not person first, but with severe and chronic medical conditions. So children that are maybe medically fragile or have severe problems can receive a home Medicaid waiver. And these are for children with maybe familial dystonia, Rett syndrome, severe neurological disorders that would require in-home nursing care. The interesting thing about a Medicaid waiver is that it bypasses the Medicaid income eligibility requirements. So children up to age 18 years old can receive long-term care and skilled nursing care at home. This is a godsend to families who have children with these particular types of disorders. And it's important for a family to be referred to OPWDD to connect with services. And we'll talk about those linkages as we move through this part of the presentation. Remember, though, that Medicaid waiver is usually for more severely developmentally disabled children. Some additional types of programs for children. There are family support programs through the Office of People with Developmental Disabilities. Some are for advocacy. If a child is having trouble getting their educational program to work for them, to provide educational benefit as defined under IDEA, they can get some advocacy help through OPWDD. There's also after-school respite and school vacation respite and weekend respite that families can apply for, as well as family training and support. Say you have a child that's on the autistic spectrum, they have a severe developmental delay, maybe there's some sibling issues going on. You could get some family training and support around sibling issues and counseling for the family. So there's individual and group training sessions to help families of people with developmental disabilities, both to follow through with the physician's treatment plan, to obtain specific instructions about preparing for the child's transition from special education to adult services, so if they're in that age group, and to enroll in community programs post-transition. Again, continuing with family support programs, there's also service coordination or case management for people who are not eligible for Medicaid, who need some help with managing all the myriad services that their child's receiving. There's also voucher reimbursement to purchase goods and services which can't be funded through other sources. For example, in-home respite, ABA in the home, camp, recreation programs. So here's the most important thing to take away. It's impossible in one lecture to get into all the family support programs and services available through OPWDD, and I'm seeing that I didn't change the name on the slide. This was one of the changes I was making as I went through. But OPWDD, as I said, has regional offices. Our region here in Western New York covers all 8 Western New York counties. Our regional coordinator is Cicely Pinecoffer. Her phone number is 716-517-3423, or you can reach her by email at cicely.pinecoffer@opwdd.ny.gov. There's also programs available for adults through the Office of People with Developmental Disabilities. There are aging services. Our people with developmental disabilities, thanks to the excellent medical care that they are receiving now, rather than institutionalized care, they're in homes, they're in the communities, and they're living longer, happier lives. We now need senior daycare for our adults with developmental disabilities, and also caregiver supports and specialized residential supports. There are also community residences available for independent living if the person with a developmental disability wants to live outside of their family home as an adult. There are individual residence alternatives, or IRAs. They're less restricted. They're staffed based on individual need. They provide community health care. And then there's intermediate care facilities, or ICFs. These are the highest level of staffing for the most severely, the individuals with the most severe disabilities, and there's health care on site. So those are a couple alternatives available. We're finding that there's more and more need for community residences for people with developmental disabilities, and so there's more flexibility that's beginning to be available for those types of residences in the community, but it's hard to cobble together the funding for that. as I mentioned before, the other thing that the Office of People with Developmental Disabilities does is provide Medicaid service coordination, and through that, they will help with making sure that the person with a developmental disability is receiving their appropriate educational services. They'll help with making sure the IEP is correct based on their developmental disability. They help the parent understand their responsibilities. For adults 18 years and older, they may be working with the individualized service environment for the adult with a developmental disability. They help with their individualized service plan, and they make sure that the person who's responsible for that plan understands the plan in its entirety and how to implement it within the community. In addition, the Office of People with Developmental Disabilities provides coordination of home and community-based Medicaid waiver services. Waiver services for children and adults with Medicaid can include residential habilitation or in-home life skills training, day habilitation for community integration, pre-vocational services, volunteer work and job training, supported employment such as job coaching and interview training, respite service, both freestanding and in-home, and environmental modifications, ramps, grab bars, etc., and also adaptive technologies such as communication devices. So, as we're talking about services, eligibility requirements for all OPWDD funded programs requires qualification, and these qualifications are modeled on that definition that we talked about for the Developmental Disability Bill of Rights. So in order to qualify for services under OPWDD, you have to have one of a variety of conditions that become apparent during childhood and cause mental or physical limitation. These conditions include autism spectrum disorders, cerebral palsy, epilepsy, family dystonia, this is included as of 2005, mental retardation, traumatic brain injury before age 22, which can be problematic for our people in military service, and other neurological impairments. Now, these are requirements, these following requirements are for all OPWDD funded programs. So you have to have a medically documented developmental disability, age of onset prior to 22nd birthday. You have to have a full-scale IQ of 60 or less. And if the applicant's full-scale IQ is above 60, say somebody on the autism spectrum with Asperger, like I mentioned before, he or she must have a documented adaptive behavior deficit. So you'd have to have something like a Vineland adaptive behavior scale or something like that with a composite score of 70 or below, because that means that your adaptive behaviors, maybe your ability to communicate effectively for a job situation, your ability to engage in physical hygiene issues is not what it should be, or there's something going on where you have some of these adaptive behavioral problems that are limiting you, that have nothing to do with your IQ, but have everything to do with your developmental disability diagnosis. So again, continuing with qualifications for OPWDD services, you also need a physician's documentation of a developmental disability with an onset prior to the 22nd birthday. So it's imperative that you get that diagnosis early from the physician's office. This is where you all come into play. You want to make sure that as you're charting someone throughout their young life and into adulthood, that definitive diagnosis gets made before age 22, and that you don't wait, because it can really have a domino effect for qualifying for services later in life. This can be in the form of a letter that's written by the physician that confirms the child/adult's diagnosis and explains the specific areas of functional deficits that are a result of the disability. And take the time here. Make sure that you interview the family, you find out where those functional deficits are, that it all gets documented and charted. You're really falling down on the job if this isn't done, because it has a domino effect for the rest of this person's life in terms of eligibility for services. The other piece that's critically important is a medical evaluation that's completed less than 1 year before the application. Remember, this is separate from the diagnosis. This is a recent medical evaluation, and then an ICF level of care eligibility determination that's signed by a physician and an OMR, or not OMR, Office of People with OPW DD, Qualified Mental Retardation Professional, a QMRF. This is important to know what type of care this person is going to need prospectively. The other type of office that's available to people with developmental disabilities is oftentimes the Office of Mental Health. Intuitively, people don't always put together OPWDD with OMH, but you may be surprised, or maybe you won't, depending how long you've been in practice, to know that many people with developmental disabilities also have a comorbid diagnosis within the mental health system. Most of the time, that's around maybe OCD, some obsessive compulsive disorder, anxiety disorders. Depression is very common, severe depression, severe anxiety, and a lot of OCD. These things aren't always easily treatable within OPWDD, and the OMH diagnosis needs to be made in order to get the type of services, whether they're on an emergency basis, inpatient, outpatient, or community support programs. In order to provide the linkage, the diagnosis needs to be made. And oftentimes you have people trying to navigate both these systems, OPWDD and OMH, that themselves do not have necessarily a high level of education, probably not college educated, maybe reading, most likely reading at about an 8th grade level. These are the parents and loved ones and support system for the person who's trying to qualify for service. So it makes it imperative that readable, plain language information is available to families. And that's where, getting back to my conversation earlier about the legal rights of parents of children with disabilities through IDEA, the fact that it can be put into a nutshell form that's 1 page long, as opposed to, the 44-page tome that's presented to families for their procedural safeguards notice. It's something to really think about for all of this information. In no way am I suggesting it should be dumbed down. What I'm suggesting is that the language that we use for any profession, whether it's a medical profession, an educational profession, a legal profession, we need to bear in mind our audience, and we need to think about how can we present this information in a simple, clear way that conveys the information effectively to families who are in crisis or who are under stress, trying to provide services for a loved one with some acute needs. So getting back to the Office of Mental Health, the types of programs that are available through the Office of Mental Health are emergency services. The idea is to provide rapid psychiatric or medical stabilization if someone's in crisis, and ensure the safety of the individuals who present as a risk to themselves or to others. This can happen with depression quite often in the population of OMRDD, especially with higher functioning young people who recognize that they're different and become concerned about fitting in that very difficult high school time period. There's also inpatient services. There's objectives of inpatient programs to provide acute stabilization and intensive treatment and rehabilitation. They usually have 24-hour care. There's also outpatient, which is the objectives. The objectives of the outpatient programs are symptom reduction, treatment, and rehabilitation. They may also follow to make sure medication is being taken properly. And then also community support programs. The objectives of community support programs are to help adults live as independently as possible, but within the community. You can see here that the Office of Mental Health provides restorative services, and they provide these services within the mental health system. They provide diagnosis, and you can see by these charts that the percentages of the different types of diagnoses that we see within New York State's public mental health system. With the largest diagnoses being schizophrenia and other psychotic disorders that are treated by this public mental health system for adults. And then for children, you can see that there's a lot of children who are accessing public mental health system for attention deficit disorder and mood disorders or depression and conduct disorders. The OMH system serves approximately 400,000 adults and 100,000 children and adolescents each year. And it's just a really large number of people within our communities that really require these services. To summarize, what I would say is very important is that people with developmental disabilities have to choose a system that best serves their individual needs. OPWDD is the primary New York State agency for providing services for people with developmental disability. And things to remember, physicians have to screen for DD at each well child visit and refer a child to EI with parental consent within 2 business days after screening. Also, school districts are mandated to provide both educational interventions and related services until the age of 21 or graduation, whichever comes first. Thirdly, the Committee on Special Education is legally bound to develop an individualized education plan and provide the needed services specified in that plan for qualified students. Fourth thing to know, adult services can begin at 18 years old, even if the person is still in school. So what I recommend is if you have a young person with a developmental disability who's being seen at your offices, make sure that the parents are aware that services can begin at age 18 through OPWDD. Make sure that transition services within the IEP, these are services that are preparing the student for adult outcomes. Make sure that that IEP includes linkage to OPWDD for this young person. And the other thing to keep in mind, which again is another lecture entirely, which I'd be happy to share, is that you need to keep in mind that when a person with a developmental disability becomes age 18, they are an adult in the eyes of the law in New York State. And because of HIPAA and the privacy constraints that go with that law at age 18, their medical information becomes private to them and is no longer available to their family or loved ones who've been caregivers all of these years. So what I need to say to you is, if this is a person with a developmental disability who will not be able to make life decisions as an adult, that family needs to start making decisions around age 17 years about pursuing legal guardianship of that person with a disability. And that's a process that's done through surrogate court. A lot of people do involve attorneys, but it doesn't have to involve an attorney. The surrogate court is very good about walking families through that paperwork and helping them file independently if finances are an issue. So just something to keep in mind, along with this fact that a child or a young person, that once they turn age 18, they're both eligible for OPWDD services, which is really good, but they're also an adult, and all those HIPAA privacy rules fall into place for them, and we need to think about legal guardianship at age 17, a year before that. Start the process. Again, another lecture. And then the last thing on this slide would be that children and adults with developmental disabilities need a physician's confirmation, an explanation of their diagnosis to apply for OPWDD services and health insurance benefits. Make sure that the developmental disability is charted and put into that child's records, medical records, before age 22. Don't wait. Okay, so that concludes this lecture. Again, if you have any questions, my name is Elizabeth Wright. I'm happy to answer your questions by email. My email is ewright2@damon.edu. And I hope you've learned something today and that it's useful for you in your practice. Thank you.